We've been looking at how America got to the place of securing what has been a long-running, multi-hundred-year sacrosanct right that's only been fortified or built up over time against governments or king-like politicians' desires to abuse detention powers. Now, there are moments, to be sure, where those rights that I've been telling you about have indeed been suspended. After Pearl Harbor, which was the actual World War that most legal experts say is the kind of thing, unlike a fake war or fake invasion, that can trigger certain enhanced presidential powers, there were great fears of how the Japanese opponents and enemies might come in or abuse situations in the U.S. And so there was an executive order that actually didn't work very well, according to most folks who's ever looked into this and historians, seen as kind of a panic of the time, although it also was an existential World War scenario. But it basically made a giant over-inclusive category and tried to take people of any Japanese descent without any other security analysis and put them into internment camps in the U.S. And the Supreme Court ruled in Korematsu that that was, at the time in war, a national security constitutional act. So that's what it looked like in one of the rare times this has happened. But most scholars, legal experts, and even many military experts say that that was not the right call with all the facts in. And if you go to law school and you talk to judges, including many Federalist Society conservative judges and legal experts, they say it's one of the worst Supreme Court decisions ever. Here's President Reagan, who issued an apology for the action.
120,000 persons of Japanese ancestry living in the United States were forcibly removed from their homes and placed in makeshift internment camps. This action was taken without trial, without jury. It was based solely on race. Yet we must recognize that the internment of Japanese Americans was just that, a mistake.
A mistake as policy and legally. Well, again, in the moment you can say it was lawful in the sense that some bad things are lawful at the time, but it is not a precedent that any serious mainstream figure in law or military expertise has pointed to for support in a long time. Reagan even established a Civil Liberties Act, which acknowledged what he called that mistake and injustice. Now, Trump's Solicitor General John Sauer actually brought this up during his confirmation hearing in agreement with the idea that it was a mistake.
I believe there was a court order there that upheld, which has now been, I think, correctly repudiated by virtually everyone, a court order that upheld the internment of Japanese civilians in internment camps during.
As bad as it was, that court order was followed for years, was it not?
And I just wonder whether some historians might think we'd be better off if it hadn't been followed.
He wonders, in that example, if that abuse of government detention power should have not been followed. This is why they call it clever lawyering, because he works for an administration that has gone farther, not as far as Korematsu, nobody's saying that, but has gone farther than other administrations to stretch wartime detention powers, claiming a war right now, and then he's citing that in the opposite. Now, Trump wants to deport more people, and there are many ways he can do that that are constitutional. But he's also sending out lawyers to push the courts past the very lines they draw. And there's some very clear hypocrisy on the record. A special report right now on the core rights and liberty protections the Trump administration has been both attacking and very brazenly testing in the highest courts in the land. The push begins with Trump's mass deportation agenda, the people being hauled on and off planes and sent to various parts and corners of the world, but it doesn't necessarily stop there. This has actually drawn a string of losses in federal courts, rebukes from multiple judges, orders to bring back, sometimes wrongly, deported individuals. There's been the Supreme Court losses in the early rounds. You're probably familiar with some of that, but as Donald Trump keeps pushing, we now have this standoff between him and the courts, as the Wall Street Journal reports, and this is the current baseline. And these clashes already go beyond even the tense standoffs over foreign detainee rules during the war on terror. We're past where we were then under Trump in the second term. And the president's challenge is to the law and the Constitution in a way that could go even farther than those clashes. Indeed, Trump's number 2 official in the White House, Deputy Chief of Staff Stephen Miller, has asserted, he says, the administration is mulling ways to suspend the core, long-standing liberty right against unlawful or unlimited government detention powers that they claim they're already looking at how to suspend habeas corpus.
The Constitution is clear, and that, of course, is the supreme law of the land, that the privilege of the writ of habeas corpus can be suspended in a time of invasion. So I would say that's an option we're actively looking at. Look, a lot of it depends on whether the courts do the right thing or not.
That's their stance. They're, quote, actively looking at it, and then he adds a kind of a bluster toward the courts. Be careful, if you don't do the, quote, right thing, which means agree with Trump on just about everything, maybe they'll suspend this right. Now, in our special report right now, I want to be very clear about this baseline. In any era in American history, claims to suspend that core right of the Constitution are a huge deal. That Latin phrase, habeas corpus, is one of the most important and vital rights that people have in their dealings with the government. The founders were clear that that right would operate in the Constitution, so no politician and no Congress can repeal it, and it would operate permanently to limit government powers against the people. That is the baseline. And while, yes, there are times where you might have an actual emergency or a world war, that would also be enumerated. You can't just suspend the right because you don't like dissent or you have a different immigration policy. It could only be done, suspended in the case of wartime invasion or emergency public safety. That's what it says in the Constitution. It means something good. It means most presidents have never even gone near suspending it or even talking about how they could. That's even after obviously shared public safety disasters and emergencies like the 9/11 attacks. And while Mr. Miller could be exaggerating, political aides have been known to do that. On the deportation front, let's draw a direct line to his threat and what the administration has already done. Rush to formally claim war powers in those first 100 days, a period where Americans do know, whether you follow all this stuff closely or not, that there was no declared war or new war. But that's part of the asserted war powers that the new president in his second term tried to assert by citing the old Wartime Alien Enemies Act, which judges then rejected because there's no war on the southern border. And the White House, as one judge put it, failed to prove any invasion. Now, the history here is instructive. America's had its share of wars and, obviously related to that, intense debates about both wars themselves, whether to start them, where to wage them, and then the attendant powers that come alongside big wars. Protests over those war powers or government overreach. Consider the huge power of drafting people into battle, which is part of what animated the wider opposition to Vietnam. Debates over how the U.S. treats people abroad during war, whether it follows human rights. And I want to turn with you to history's lessons tonight because this is a very important thing we're going to be living through. Some of them have possibly bad news for Trump's claims through his DOJ lawyers. But the current clashes are telling, as the administration is not exactly shy about its claims that it can suspend rights, something they say they may do further, or that they have war powers. In fact, we just pressed top administration border czar Tom Homan about this. Another judge said the White House failed to prove the existence of the invasion or conflict required to justify invoking that act. You've been blocked from using those wartime powers.
You don't have to be at war for alien enemies. They also can be a predatory incursion. That's what we believe happened.
Mr. Homan, I'll tell you, so you have the benefit of knowing, this is a Texas-appointed judge. I have the quote on the screen. This term invaded concerns warfare. So not people crossing what you're calling predatory. But anyway, my key point to you is now the Supreme Court limited that. You're going to follow that unless and until the courts change it. Is that correct?
Of course we won't follow the Supreme Court.
Now, this is playing out at the Supreme Court, and it has allowed certain types of deportations while requiring actual, real due process. And remember, the founders were concerned, as we're going to see, that wherever you set the minimum line, it's going to have implications, because wherever the minimum is what some people will go through if the government accuses you, for example, of being here unlawfully. Now, Justice Sotomayor has warned about some of these problems, saying citizens under the Trump claims could be taken off the streets, forced onto planes. And again, I'm going to leave this up for a moment because she says U.S. citizens. She's talking to the public and the Trump administration. And for those who say, oh, well, this is only for unlawful migrants or new people who came here, she knows how things work. She understands the law, and then says this: history is no stranger to such lawless regimes, but this nation's system of laws is designed to prevent, not enable their rise. Sotomayor discussing the centuries that have led up to these protections that guarantee these rights for citizens. In fact, you can trace it back all the way from before this country was founded in the rebellion we've all learned about, the revolution we all study against kings and their kingly abuses of power. You can go all the way back to about 13th century England and the Magna Carta, which was the initial attempt to try to have some sort of peace between what was then an unpopular king, because a lot of times when you ask the people, they don't like these kings, and some rebels. And there was the idea that it would be a bartered way to have at least a basic protection from illegal imprisonment. Now, that is a ways back. The world operated completely differently. The notion of who was even a full human and what rights were and whether kings were ruling from godlike decrees was a different time. But even then, this is my point to you tonight as we think about whether folks want to take us backwards in history, the basic line of human rights was the idea that they would start checking the king's power, which began with detaining people.
See that judges are furious with Trump in court, and they're saying it, like exasperated, like the documents they're putting out where the judge is using exclamation points and things like that. This is stunning stuff. Judges often don't even try to write angrily, and I get it, because they want to be as impartial as possible. They want to be as measured as possible. The best judges in the country, and most of them do their best, most of them do, really believe that they have, correctly, an immense amount of power. Not just like the power to lock someone up, or the power to free someone, or the power to, rule big financial penalties on people or rewards to people, all of those things, right? But just their cultural power. Like when a judge speaks, when a judge writes, whatever, people listen. And so judges often, I gotta be measured, because I'm not just speaking for me. In my job, I'm speaking on behalf of the people of the U.S. government. But also, like, I'm speaking to history, and I have to understand that my words carry weight. Everyone has that. Everyone's words matter, but if you're just some guy or some gal and you yell about Trump and write exclamation points about Trump, no one cares. But if you're a judge, it matters. And what judges are making clear is that Trump and his team are spitting in the face of justice and due process, and they are sick and tired of it.